Hello there. Welcome. This is a Disability Law Show. You bet. John Scholes here. Back with us again this week. James Fireman, Tamar, Agopian, Samfiru, Tumarkin, LLP, the most positively reviewed law firm in the country. Both these amazing disability lawyers are reachable anytime. Here's the phone call right off the top, 1-855-821-5900. You prefer the email route, you can do that, help@disabilityrights.ca. And just to get to the firm website, disabilityrights.ca, under Knowledge Center, drop-down menu Media, you'll find past TV shows and links to our long-running radio shows across the country as well. Again, disabilityrights.ca. On the show today, in just a bit, what you should know about your medical files while on LTD. That's coming up in just a little while, but we always start off, guys, with the week that was, something that's been happening. This time it's going to be up to you, Tamar.
It's a super week whenever I get an excellent resolution for a client, and
Nice.
I'm just itching to share this with our viewers. Of course, I'm going to preserve his confidentiality and his privacy, but just generally speaking, I wanted to touch on a key issue, which is compliance issues. We don't talk about it a lot on our shows, but that can be a reason for why a disability insurer will deny a claim, is if you have not been compliant with certain terms and conditions of the policy, perhaps, or some things that they have asked you to do during the course of the adjudication of the claim. And with respect to my client, it was a mental health disability situation. He was really having a hard time accessing treatment. And as we know, in these disability policies, there's always an appropriate treatment requirement. That disability benefit will only be issued and paid if not only you meet the test of total disability, so in his case, an inability to do the essential duties of his job, but also that he's making efforts to recover and actually get better and be under appropriate treatment. And with mental health disabilities in particular, John, and James will know this as well, the last few years have been really difficult for an access to treatment issue, number one. And number two, these are the types of disabilities sometimes where it can be somewhat bumpy. Insurers have come a little bit of ways, but frankly, sometimes not far enough in recognizing how disabling these conditions can be, and that their adjudication in and of itself can sometimes exacerbate what is an otherwise underlying mental health condition for someone like this. And my client was absolutely in this type of zone. And so, very aggressive adjuster. He's struggling with trying to get treatment. The insurer is sort of pressing in terms of, well, we need to hear from you every 30 days, or we need to hear from you on this or that. He buckles under that pressure. He starts to become a little bit unresponsive, naturally, not surprising with individuals with depression, anxiety, and other mental health conditions. And the adjuster was just not recognizing what was happening in his situation. A very aggressive rehabilitation plan was then put in place to try and get him better, quote unquote. But really, we know that insurers are trying to implement these things so that they can fast track and close out the claim, get them back to work sooner than they're ready to. And he was struggling with actually making it to the appointments to do all of the things that was set up in this very short window of time. On top of everything else, he gets COVID. So they put in this rehab plan. He's expected to actually attend in person. He gets COVID, and he's advised to isolate. So he tries to explain this to the insurer, and they say, you're not being compliant, you didn't attend. And in fact, he had tried to reschedule the appointments that he wasn't able to do in person to pivot, to try and do them over the phone or do them virtually. And even in the context of all of that, the insurer said, 3 strikes, you're out. We're going to just simply cut off your disability claim. You can only imagine what situation he was in all of that. He came to us, had a consultation with us, absolutely free. I said to him, you must allow me to help you. I want to help. I want to start a legal claim. I want to put the insurer's feet to the fire so that they are acting reasonably, something that they haven't done with you through the course of your whole adjudication. And we managed to resolve the claim within a year of being retained. Huge success story. He's absolutely relieved. He's finally getting the compensation that he needs. I can go on, but honestly, to me, it was such a rewarding experience and really just a great step forward for this individual. And I feel like it was just a good day's job well done.
James died. He jumped in there. I saw the look on your face. I'm like, oh no, here it comes.
So, I mean, obviously, I deal with mental health claims a lot. And so, when Tamar's talking about the lack of mental health care, and frankly, lack of primary health care in Canada, It is something that is prevalent across the country, but certainly is even worse when you go into rural areas, especially with mental health. It's almost impossible for some people to find adequate mental health care. Right. And so what are you supposed to do? I mean, are you supposed to, if you're living in northern Alberta, are you supposed to drive 5 hours down to Edmonton every time you want to have, a therapy session? Is that reasonable? I don't know. I don't know what you're supposed to do in those situations, but the test is one of reasonableness, and it's certainly not 3 strikes and you're out. That's baseball and that's it. Does not apply to disability claims, and if your insurer is telling you that that's the 3rd time and therefore you're not entitled to benefits, it's a crock. Yep. It is not the way that it works, full stop. If you are doing what you reasonably can, that is enough. And so we have to look at this in 2 different ways. We have to look at this in terms of what do you do when you're in that situation, and then what happens afterwards if you're cut off as a result. The cutting off as a result, you call us and we're going to help you with it. That is easy to deal with from our perspective. But ideally, you want to avoid being in that situation in the first place. Right. You want to figure out a way to at least prolong the period of time that you're getting benefits. And so what do you do if you're in that situation? Well, the first thing you want to do is make sure, assuming that you have primary care, assuming that you have a family doctor that you're seeing on a at least semi-regular basis, you want to make sure that they are involved in the process as much as possible. And I know that can be difficult. I know that there are family doctors that are less willing to become involved in this process. And that's unfortunate. And in those situations, there may not be a lot that you can do. But if you have a supportive family doctor, even if you're not sure, take a shot. If your disability insurer is telling you that you have to go through, this very aggressive return to work program, or whatever they call it. Sometimes it's a progressive goal attainment program. They have all sorts of language for it, but essentially it is a very brief rehab designed to get you back at work. If that's what they're trying to do, then what you want to make sure is you get the details of what's going to be involved in that program, what kind of treatment there's going to be, how frequently you're supposed to go, where it is, and you give that to your doctor, and you get your doctor to review it and provide a written response as to whether or not it is appropriate that you submit to that treatment. And if your doctor says it's not, then there is at least a possibility that your insurer is going to say, okay, maybe we need to take another look at that. Because if they don't, and they force you to comply with this program where they have a treating doctor saying that it is inappropriate and it's in fact going to make you worse, then they are opening themselves up to a very significant claim for punitive damages, and they don't want to do that. So that is a very effective first step that you can do if you have a doctor who's at least willing to write that for you and provide it to the insurer.
A lot of stress and trouble for this particular individual, Tamar. How soon could he have gotten you guys involved so the phone calls stop, which they love? That's the best part.
It is the best part. And I think the even better part for me was that he came to us fairly early. Good. And so we expected that this may have occurred. I projected it. I said, look, they're obviously putting you into this plan for a reason. And, consequences. The reality is that he was advised medically not to attend in person. So to James's point, when you've got that medical advice, you absolutely can rely upon it when the insurer is being unreasonable. That's the key. And so, look, we got involved right away, John, and what we do, by the way, is we write to the insurer right away. We get retained, we put them on notice, we let them know, look, we're starting a legal claim. All of those phone calls stop. I want your complete file, by the way. The file was a gold mine, no surprise there, of all sorts of things that they should have done that they didn't do. We can email you, but you can't email us back. You've got to call us. Imagine that. So what's good for the goose is not always good for the gander when you talk about insurance companies. But in any event, it allowed us to have really meaningful conversations with their lawyer, not the adjuster who was being ridiculous with my client, but their lawyer who was assigned, who knew that if they had to stand before a court and explain all of this, they were not in a good position to do that, because not only did they pull the rug from under him as it related to treatment that he actually needed, but also pulled away the financial resources that he needed to continue, not only to live and survive. Anyway, I could go on, but at the end of the day, it was a successful resolution in a very efficient way.
There's a website called pocketemploymentlawyer.ca. I know it's got employment baked in there, so it's usually on the other show that we do, the Employment Law Show. But I know, Tamar, you're a big fan of this because there's a robust little section on there about disability law. How does it help you out?
Well, I'm a big fan because I am one of the few lawyers at our firm that not only practices disability law, but also employment law. And I think that this is the way that this intersection is so important. And pocketemploymentlawyer.ca is very similar to that effect. It was conceived of to allow individuals to get some quick advice around what severance they might be entitled to, but also has an add-on piece as it relates to long-term disability. So if you're curious about whether or not your issues can be responded to by a lawyer, if you want to take that additional step and have a consultation with us, great. But if you don't, and you just want to get a little bit of quick advice, this is an excellent tool, plug and play, very, very easy to use, completely anonymous. You can close out the browser, you're fine, move on.
Again, pocketemploymentlawyer.ca is that one, but if you go to disabilityrights.ca, the firm website, the Knowledge Center media tab, you'll find a radio station pretty much across the country where we've been hosting radio shows for years and years. Got a lot of great phone calls on those shows weekly. We'll have to play some of them back here and talk about them. Our first phone call for this show today is coming up right now.
Sister, currently on long-term disability. She was working for the employer who was the insurance company's paying her long-term disability payment, but now she's also collecting, I believe it's CPP, and they're deducting that amount from her benefit. Is that something that is correct?
So this is a good question. It comes up all the time. So let's first take a step back and talk about CPP disability. So CPP disability is a program run by the federal government, and if you are paying into the Canada Pension Plan, CPP, then if you have a disability that's preventing you from working, you're entitled to apply. Now, the test for CPP disability is a little bit more onerous. It requires a severe and prolonged disability. So that is, generally speaking, going to be more difficult to get approved for than your typical long-term disability policy, which also, by the way, means if you are approved for CPP disability, that's a very strong argument that you should be approved for LTD as well. But the question here is asking about whether or not the insurance company is entitled to deduct those CPP disability payments. And unfortunately, in most cases, the answer is yes. Now, I say most cases because not all policies are the same. Certainly, if you have a private policy, you want to look real carefully because in my experience, most private disability policies don't have the ability for the insurer to offset the CPP disability amount. But for a group disability policy, the vast majority of them will have that language in there. Now, you want to be careful and make sure that it is, especially with older policies. Sometimes you'll see gaps. But for the most part, if you have a disability policy through your group insurance, your insurance company will be entitled to deduct the monthly CPP disability amount. So, for example, if your monthly LTD payment is $4,000 and then you apply for CPP disability and you're approved and the government approves you for, say, $1,500 per month. What's going to happen is the insurer is going to say, okay, you're getting $1,500 from the government. Instead of $4,000, we're only going to pay you $2,500 now. Yep. So that is typically the way that it goes. So unfortunately, it is probably the case that your sister's CPP benefits are deductible from the LTD, but again, look at the policy to be sure.
But generally, you're still made whole at the end of the day.
You are made whole, but sometimes what ends up happening, John, is that the disability insurance that you're getting from the disability insurer is non-taxable, whereas CPP disability is a taxable policy, and so, or a taxable plan, so you will be taxed on that component of it. Now, a lot of our clients will also apply for the disability tax credit,
right.
So some of that money can come back in that context, but generally speaking, yes, you should be theoretically made almost whole as if you were getting all the sum of income from the disability insurer. But I can't agree with James more that the policy is really important. I actually recently had a huge debate with one of the insurers about what their policy said about the CPP disability, because some policies will say you have to appeal a decline decision. Some policies don't speak to it at all. Some will use language like if you're eligible, you get it. Others just say we can estimate it and we'll deduct it from your disability policy or benefit regardless of whether or not you're getting it or not. And so some insurers will take a very aggressive approach on the CPP disability deduction. Guess why? Because it means they pay you less at the end of the day. So the policy wording is very critical in whether or not the insurer gets to take their pound of flesh and how much and how that calculation all works.
That's an interesting point you made too. If you neglect to apply for CPP, they're going to assume or make an adjustment. You probably would have got this much, so we're going to deduct it by this much. Yeah.
Yeah, we see that happen when we bring litigation all the time, but that's an argument we can deal with. And I also just wanted to add, I heard Tamar talk about the disability tax credit, and I am quite sure that our old friend Terry Corcoran is smiling down on hearing that, because that is a drum that he would beat on constantly. Apply for the disability tax credit because you're likely going to be entitled to it if you're getting CPP disability.
What you should know about your medical documentation when on LTD, we'll get to that after a short break. In the meantime, I'll give you the number to reach out to these guys or anybody at the firm. On that side, it's 1-855-821-5900, help@disabilityrights.ca. We continue. This is a Disability Law Show. Hang in. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back. Thanks for hanging in through the break. Disability Law Show. John Scholes. I'm your host. Along with me, James Fireman, Tamar Agopian from Samfiru, Tumarkin, LLP. You can reach out anytime. Start with that phone call, right? 1-855-821-5900. help@disabilityrights.ca. Guys, main topic. It's that time of the show. What you should know about your medical files while on LTD. Point number one, doctor's reports should be detailed and specify why an individual is unable to work.
The details are so important, John. They're so important because there are so many disabilities that, frankly, an adjuster just doesn't understand. So these adjusters, the ones that are actually looking at these disability claims and files and applications, many of them don't have any medical background at all whatsoever. The only tool actually most of them have is like a WebMD type thing where they go on a Google and they'll put in your medical diagnosis and it'll pop up, in 6 to 8 weeks, this person should be back at work. And that's just simply not sufficient. It usually doesn't line up with the advice that actual treating practitioners are giving to their patients. And so when that kind of advice is being given, you want to make sure that it's well documented. And it's not just the prognosis, as in how long it's going to take for someone to recover, perhaps with concerted treatment, but also what does that treatment look like? What are the symptoms specifically that this individual is struggling with? And how do those symptoms and the limitations in their function line up with their job duties? So a lot of the times, it could be that an individual hasn't even shared with their doctor that I've got a physical job. So when I am coming to you, doc, with physical health limitations, sometimes the doctors won't make those connections. And fair enough, the doctors don't necessarily need to. But then that's why the details around those symptoms and limitations in function become so important, because that's really all sometimes an adjuster is going off of.
Number two, guys, an absence of a report or letter from your doctor supporting an LTD claim could lead to a denial of benefits. James, what do you think?
Well, so here I start thinking about what you're typically going to find in a medical chart. So whenever we're hired by a client, one of the first things we're going to do is we're going to write to all of the treating doctors and get their medical file. And what we're usually going to see in there is simply a collection of the clinical notes. So every time you go to visit that doctor, they're going to take notes. Some of them do a better job than others, but they're going to take notes about the visit, about why you were there and what was discussed. Usually that's about the extent of it. You'll see test results from other doctors as well, x-rays, what have you, blood work. But that's what's typically going to be in there. And the reason for that is pretty simple. The doctor's job is to provide medical care. They're not really there thinking about your disability insurance or in most cases, how it relates to your ability to work. Now, sometimes they will go so far as to write you a letter that says that you're not medically fit to return to work, but that's usually about the extent of what will be in there. It is almost certainly going to be intentionally vague. For the purposes of an insurance claim, a disability insurance claim, there really does need to be more. And so it is critical that you ask your doctor to provide the exact kind of report that Tamar was talking about, that's going to have the details about the history of your treatment, about the prognosis, and most importantly, how that relates to your functional ability to do your job. So it is important that your doctor understands what you do, and you shouldn't assume that they do. You shouldn't assume that everybody understands what your job entails, because the reality is, even if you know what your title is, that particular job may be different with your employer than it is somewhere else. And so it is important to have the conversation with your doctor. Listen, these are my duties and responsibilities. If you have a physical disability, these are the things that I'm required to do physically on a day-to-day basis. If it's mental health, you want to talk about the responsibilities that you have, or the type of cognitive load that's required of you, or the requirement to interact with other people. Whatever it is that you feel like you're not functionally able to do, you want to make sure your doctor understands that that is a requirement, and then puts pen to paper and is very clear about how your disability is functionally preventing you from being able to do your job. If you don't have that in there, then essentially what you're doing is you're hoping that the adjuster is going to read through the records carefully and connect the dots for you in a way that's going to relate to your work. And if you're expecting that to happen, then you're kidding yourself, because adjusters really aren't looking for a way to approve your benefits. They're looking for the opposite. So unless you give it to them on a silver platter that connects the dots for them, that literally draws that line from A to B, they're going to say, well, I don't see any connection here. You're not disabled. Sorry. So it is critical that you have those reports in there. And this isn't something that you need to get from your doctor every month, right? This is an undertaking. You're asking your doctor to do something to help your insurance claim, and it's not what they usually do. And I'm not suggesting you need to impose a greater duty on your doctor or waste their time in any particular way. Having said that, if you do have an ongoing claim over a number of years, it is important to update that at least periodically. And how often is periodically? It depends on your particular disability. Maybe it's once a year, maybe it's every 2 years, maybe it's every 6 months. Do what you think is going to be reasonable, and frankly, what you think your doctor is going to agree to do. You don't want to get in the way of that relationship with your doctor either. No. So you want to make sure that what you're asking for is not going to be a great burden on your doctor. God knows they have enough things that they have to do. This is an ask. This is something that we're asking them to do, but it is something that the people that contact us genuinely need. So you should ask if you need it.
What you should know about your medical files while on LTD, that's what we were talking about. Point number 3, I'll give to you, Tamar. It is treating doctors are able and should speak to a disability lawyer if they're unsure of what is required.
Absolutely. We're more than happy to speak with our clients, doctors, treating providers, even if they're not our clients. Any medical practitioner, most of them don't know how to navigate this, right, John? And what I was going to add to our prior conversation around medical reports is that a lot of the time patients will go to their doctor with just the forms that the insurance company has provided to them. And that could be the initial application forms or additional forms. I don't love forms, okay, because the forms don't allow actually for the treating practitioner to provide that context. A lot of those details don't land in a form because you've got a tiny little box to answer the question that's being directed specifically by the insurer. I would much prefer to see practitioners prepare a narrative report, a few paragraphs. I've treated this patient for X number of months or years. These are the things that I'm treating them for. This is what I'm seeing when this individual comes to see me during our visits or appointments. And I think that this is where the disability lawyers really add a lot of value to the overall profile, because most practitioners don't know how to deal with how to present this kind of information to the disability insurer. So by no means do James and I want to interfere and get in the middle of the relationship. The doctor-patient relationship is very, very important for our clients and our claimants. But if there are any questions, we're more than happy to talk through with anyone who wants to speak to us about how do I best present this? This is the situation, and we can have a 20-minute conversation with a medical practitioner and away they go. They'll write the right kind of contents and information in these kinds of reports to help the disability claimant.
You know,
Sorry, go ahead, James.
One more thing I do want to add, lest anyone think that this is a hollow promise. I can tell you that it was just 2 days ago, Savannah and I were on a call with someone who's representing a group of therapists, a very large group of therapists, that is interested in having us speak to them. We're not charging anything for it. It is just a large group of people who are involved in this process that have a lot of questions, because this is not part of what they are trained to do.
No.
But it is something that they are asked to do repeatedly, and understandably, most of them just don't understand the process, don't understand the best way to help their patients, and they genuinely want to help. And so we are a resource if you're in that situation. If you want to know how you can best help your patients, you can give us a call. You can keep it completely anonymous. We're not going to try and sign up your client. That's not what this is about. We are happy to help people that are in this situation because, frankly, it is a service that needs to be out there, and there just isn't enough information. And so if we can help treatment providers be able to help their patients, then everybody wins in that scenario, except the insurance companies. But we're okay with that.
We got enough time to grab an email before we wrap up for this particular show. In the meantime, here's the number as we go into a break: 1-855-821-5900, and that email address is help@disabilityrights.ca. We'll continue with the Disability Law Show. Stick around.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Welcome back, Disability Law Show. We got time to squeeze in one more email. Anytime for you as well. Help@disabilityrights.ca is how you send one along. It'll possibly get read on a future show. Tamar, this is for you. Peyton writes in, says, after an independent medical examination, the insurance company is recommending I switch treatment providers from my current psychotherapist to one they believe will be more helpful. If I refuse to change my therapist, can my benefits be cut off due to non-compliance?
They shouldn't be cut off, but frankly, if the insurer can find an opportunity to cut it off, I can bet you that they will. Now, let's unpack this a little bit for Peyton in the last couple minutes that we have. I actually don't like the idea of someone feeling pressure to try and change a treatment provider just because the insurer has made a recommendation to do so. I don't think you want to blindly or willy-nilly make that decision without actually consulting with your own medical team. The first question that I had was why? Why has that recommendation been made? Is there some specific treatment that Peyton needs that's not being offered or provided by their own treatment provider? Have that conversation with your team, because if you do tend to use the insurer's treatment providers, my concern is that there's some inherent bias there. Who's paying for that treatment? There's not enough arm's length there. They may be able to influence in a way or communicate with the insurer in a way that could influence bringing the claim to a closure sooner than it should. When you're dealing with your own treatment providers, you don't have to be worried about that. You know that they have your best interest at heart. They're going to do what's best for you with your health and recovery. And that pressure in terms of what the insurers biases and their intent on getting you back to work is not necessarily as present and available there as it would be if you use one of their treatment
So if you've got a
providers.
good system in place, stay the course.
Absolutely.
Yeah.
Because if it's not reasonable, then the insurer doesn't have a leg to stand on there. If they do go ahead and say you're not being compliant because you're not choosing the treatment provider that we've recommended or we think that you should be getting. So in that context, I don't think that Peyton is offside the policy requirements. If he does have enough people treating him and caring for him, that should be sufficient to continue his disability benefits.
And with that, we're done for another show. Reaching out now that we're going to wrap up, 1-855-821-5900. That's the number, help@disabilityrights.ca or just disabilityrights.ca. We'll catch you next time on the Disability Law Show. Thanks for tuning in.